So, as Dirk already mentioned, right, everybody is talking about AI. And since around 1.5 years, Microsoft provided the OpenAI services on Azure. And when I saw that, I immediately thought, I have to create my own version of Chat GPT. And I will ask this version everything that is blocked on the public version. So maybe you thought the same. I mean, how difficult could that be to use such a service in the Azure environment, right? And indeed, when I logged in to Azure portal, it was so easy to create that ChatGPT version, at least from a technical point of view. So, but the more I dealt with that topic, the more question came up to me. Is it allowed to use such a version? Can I really ask everything to that version? I mean, this is not so clear for me, and therefore I thought I will prepare this presentation. My name is Jean-Marc, working for KPMG, also for platform services. So we try to improve continuous improvement with automation and sustainability, together with my colleague Kishore, working for Cognizant. So when robots moved into production halls in the mid of late 20th century, they started to take over jobs of factory workers. So now generative AI almost affects almost every corner of the working world, right? And many people are start asking themselves, how safe are their jobs at the moment? A Goldman Sachs study assumes that around 2/3 of the US jobs will experience some degree of AI automation. They say that Gen AI could take over up to 1/4 of human work. This is quite a lot. If we extrapolate their estimate to the whole world, this would mean that generative AI could replace around 300 million full-time jobs with automation. However, according to this study, it also creates new professions. Gen AI will increase the labor productivity by around 1.5% annually over the next 10 years in the US market. Worldwide, this is estimated to be around 7%. But before Kishore take over the practice part, we need to know some fundamentals about the Swiss regulations. This is my part for today. So September 1st last year, there was a big revision on the already existing Federal Act of Data Protection. And it entered into force with a big revision by September. This important change also comes with a number of obligations for companies. So the first Federal Data Protection Act dates back to 1992. Since then, as well, we all have made the use of the internet, smartphones, and a lot of other technologies that is part of our everyday life. In this context, the partial revisions from 2009 and 2019 were not sufficient anymore. And another reason for the big revision on that law was the GDPR synchronization. And the new Federal Act of Data Protection should make it possible to maintain the free exchange of data within the European Union, and so to avoid a loss of competition for Swiss companies. So now you may want to know what really changed to the new Federal Act on Data Protection compared to the previous versions. So first of all, the scope changed. Maybe you already heard yesterday's speech from Dorota. She already explained about some penalties that can happen. So the new Swiss Federal Act on Data Protection only relies on personal data of natural persons, not to legal entities. Second, genetic and biometric data fall now under the definition of sensitive data. if the new Federal Act of Data Protection, the principle of privacy design and privacy by default are no longer buzzwords. As the name implies, the privacy by design principle forces developer to take the protection and respect of user privacy into account from a very beginning time. So whenever personal data are processed, the developers need to take care about it. You need to keep a register of processing activities, and the execution of data privacy impact assessment is now also mandatory in case for high risk of harm to the data subject. And also a prompt notification to the Federal Data Protection and Information Commissioner is now required in case you have a data breach. And finally, the profiling is now also part of the concept of the Federal Act of Data Protection. Due to the actual situation on the AI Act, maybe you heard about it, that the EU government finalized the AI Act last month. Here just a quick summary what the AI Act means. So first of all, the AI Act is the fundament in the EU government or market what AI is. It applies to all market participants. It doesn't matter if you're developing an application with AI, if you just deploy and provide such an application, or if you just use an AI solution-based application. The AI Act comes also with a definition of what is AI. It's clearly defined there what it is, so that you know when you have an AI system. But the most important question for you should be whether an AI system is associated with a high risk or not, or if it's even associated with an unacceptable risk. That means the application would be even prohibited. Such an AI solution could be when the system is trying to do social scoring or when it tries to influence the behavior of the user. So by the AI Act, this is not allowed. On the next slide, we will see what is the difference between the Swiss Federal Act on Data Protection and the EU GDPR. In general, it can be said that the two decrees do not contradict each other and that the controllers who comply with the GDPR are also compliant with the new Federal Act on the Swiss law. For the Swiss Federal Act on Data Protection, a legal basis is only required if you are not compliant with the principle of the Article 6 on this law, which we will see in the next slide. Overall, we can say that the Swiss Federal Act on Data Protection is less strict on legal grounds for sensitive personal data. So now maybe you want to know what is this Article 6, and this is a bit of maybe boring stuff for you because we are all engineers, but at least some topics you should be aware of it. So you should process personal data in a lawful manner and also processing in a good faith. So that means when you're processing personal data, you should be transparent to the end user, to the customer, how do you process the data and what kind of data you are processing. Also, collecting personal data for a specific purpose is only allowed there for that purpose. So if you want to use the data for something else, it's not allowed. Also ensure the accuracy of the data and take appropriate measures to correct the data. And in some cases, you need to have an explicit agreement from the user. So, for example, when you're processing sensitive personal data. Do you know what sensitive personal data are? Who thinks that the name is a sensitive data. Maybe you can hand up. It's just personal data. It's not sensitive. What's about the phone number, your personal phone number in the office? Who think it's sensitive? It's not, but your personal phone number, your private personal phone number, this is sensitive data, but not the phone number in the office. So these are sensitive data. Or other sensitive data are when you are dealing with health data or any other biometric data. All this is sensitive data. If you are dealing with high-risk profiling, then you also need to get an explicit agreement from the user. But what does this mean, high-risk profiling? Let's do an example. So if your HR department is collecting data about you, and they have to collect data about you for the employment, and that they can fulfill all the stuff, they can pay your salary and stuff like this. So they have a specific purpose behind that, which will fit to one of the topics there I said that you need to have a purpose for that. But when you think now you want to develop an AI system to further process that data, then most probably you have to do an assessment. And this assessment will come to the conclusion that this is not really needed for your employment. So that would mean to process that data further, you need to have also the agreement from the employees. The same is also for profiling by a federal body. And also when you have to give, or when HR is asking you to give an agreement, that needs to be given on a volunteer basis. So they cannot say, you have to give us. This is important to know. This is one of my favorite slides. We already heard about some fines and penalties yesterday. And they are regulated differently for the Swiss market, the EU market. And here for the GDPR, as we already learned yesterday, the penalties are relied on companies, and they are up to 20 million euro or 4% of the global annual turnover for big breaches. For less breaches, it's 10 million and 2%. And the new Federal Act on Data Protection relies on private individuals with an upper limit of 250,000 Swiss francs. And now for the AI Act, which is new, when you are implementing or using a prohibited system which belongs to an unacceptable risk, you can have a fine up to 35 million euro. This is quite a lot, or 7% of the global turnover. For other violations, you can have a fine up to 15 million. And if you are providing wrong information, even then you can have a fine up to 7.5 million euro. So when I think about the presentation yesterday from Dora, she talked about the ROI, right? For me, this is the return on incidents. And with this case, you can even have a much better ROI if you are providing an AI solution in the Swiss market and in the European market. And if you violate against all this, it can become quite expensive. But now I have talked a lot about legal theory, and I want to give the speech now to Kishore.
Thanks, John Mark. After going to the legal theory, let's talk about some implementation aspects, how we can avoid or come up with the regulation. So first step is to consider for the requirement, what are the few things we need to consider before we start with the requirement. First is know the personal data for the applications. So what kind of personal data or sensitive personal data is being used within the application. Then prepare a data dictionary for that particular data, whatever is used within the application. Then how the data is getting handled by the applications, prepare it, document it, and keep it available for the use. Well-defined roles and responsibility will give you the more handle how the data is getting handled, who is going to use that data, how the data is getting used, and what measures the people or the stakeholders should do with that data. And the more important is the training. So training of all the stakeholders who are getting involved into from the implementation to the actual users of the application. The next step is to, after the requirements are considered, next step is to consider what are the different policies and checklists. There are certain risks involved into the OpenAI setup. First risk is the privacy data breach or the confidentiality violation. Prompt injection, so it can be some Python code or something introduced as part of Python, as part of the prompt, which may interact with the internal systems and can lead to some sensitive data information leakage. Data poisoning, this is a general AI risk where the data, if the data is poisoned during the training phase, it may lead to the wrong responses. Inadequate sandboxing of the applications. If this application is not well network-wise privately isolated, it may lead to the data breach because of the internal systems access or the data access. There are many more such risks are there. To mitigate those risks, we need to define certain policies. The policies can be at the application platform level or the application level. And you will mention about the engineering platform. So this is what we are also dealing in KPMG. For the platforms, first key is to implement some technical controls. It can be data loss prevention or cloud access service broker approach or anonymization. There are various technical controls are available. Implement those. Always try to use locally hosted OpenAI within our private network. That will make whenever someone prompts are getting used, it is always within your private network. If the application is handling some sensitive information, block external integration. So with the networking, we should block all the outgoing traffic from the applications if the sensitive data is handled. To safeguard or sandbox our internal applications, we should block the internal network from using our networking configurations. Similarly, for the application side, the application should always deal with what level of data it is handling. So it should have a limit, and what kind of users it is going to use, what kind of applications it is going to integrate. So there should be a limit, clear limit. To avoid prompt injections or some confidential data violations, introduce input and output encoding and the filtering and validation to have better data responses or avoid biases within the response, have data diversity within the application at the time of training. Always system should go through the thread modeling or system testing that mechanism, and always stick to the company specific individual properties law or properties regulations that can safeguard you from the copyright violation. After knowing or defining those policies, next step is to define the checklist for the implementation and the users. Many companies are going through the curious experimentation because of this is the OpenAI is the new things, and many organizations are going through the curious experimentation. But all the users needs to understand they need to aware before productive what are the different limitations, what they should follow, what are the user guides they should follow to use that application. Employee training from the data protection point of view, it's important. Throughout the implementation, starting from the application requirement gathering to the testing and the rollout, throughout the life cycle, use internal or external data protection experts or some specialized lawyers. If you are using personal data, there has to be strict ban on entering the data, personal data, to in the prompts. Access restrictions for the users and encryptions with the in transit and at rest. If you are using personal data, pseudonymization, or if it's possible, complete anonymization will be helpful for avoid any personal data violation. Perform regular audits of the applications and ensure that the application is going through the data protection impact assessment before go live. There are many more such checklists are there. Recently, OpenAI's top 10 also released one of the checklists for the LLMs implementation that will be quite helpful for all the applications which are implementing this. After this checklist and guidelines implementation, let's talk about the reference architecture. What is the reference architecture for the applications to be defined? So all the applications has to be accessed. So web application part of this internally implemented application should be accessed only from the managed devices of the company. It can be from the internal network or VPNs and goes through the data center firewall. Then on the cloud, I think everyone using is hub and spoke network topology, continue that and have an additional firewall on the connectivity. From the application, if you are designing the applications, introduce the application gateway. This example we are talking from the Azure because in KPMG we are using Azure. Application gateway with the web configuration. The web app can be, all the resources should be configured with the private endpoint or inbound communication, and for outbound communication, use the VNet integration. Until now, or until we used the OpenAI from the Azure still not supports the VNet integration for outbound. So there is a way. So we can use the firewall outbound selected for the selected network, private network configuration, which also provides the similar configurations at the private configuration. There is one more configuration. It's going to be helpful to avoid the logs are getting out of your boundary to opt out abuse monitoring. So Azure provides the abuse monitoring feature by default. If you don't want to send these logs outside, then opt out that feature from those configuration. But it requires additional implementation within the organization to avoid such abuse monitoring. After the reference architecture is implemented or defined, the next step is for the implementation. So as this is the DevOps organization event, we always talk about how we can automate these things. Yeah. The first step is to prepare the platform engineering concept, so which provides the landing zone with the secure landing zone and also some reusable templates. We use Bicep for that. So all the resources which are like OpenAI or some networking resources, web app or Key Vault or any other resources being used, this we are created the templates for reusable, and it's going through the very rigorous testing and the policy validations to ensure that these policies are not getting violated. So these templates are reused, and we prepare the user guides for the applications to implement. The next step is the platform team to configure the network for the application team so that the private configurations are ensured and the firewalls, inbound firewalls or outbound firewalls also configured. Then the application team use those templates, implement it, and they have to ensure that all the configurations with the private outbound or private endpoint configurations are implemented. Yeah. So with this application, with this implementation, we implemented multiple applications in KPMG. One of the application is Zoe. We name it as Zoe, and this name itself is coming from this application when we entered that what should be the new name. Yeah, so the Zoe is our chat application. Similarly, there are other applications also there. We are asking before the first user of these applications to go through what are the guidelines, do's and don'ts, and what should be avoided while using those applications, and the users need to agree on those terms and conditions before using that application.
So that's it. We come to the summary. So we can summarize it to follow the processing principles like described in this Article 6 and search for the legal basis in case you need that. According to the AI Act, check the risk application of your according AI solution and apply privacy by design and use locally hosted OpenAI setup in a private network and check the checklist you see before. That's it. With this, I would like to thank you for listening, and please stay engineer and have the courage to start building OpenAI solutions without being a lawyer. And don't worry, nobody will ever be fully compliant, at least as long as there are human beings behind the scenes. Thank you.